Hello, and welcome to Arbitration Conversation. This week we have Bob Bailey. Bob Bailey is really quite extraordinary. First of all, he is the Dean Emeritus at the University of Missouri School of Law and a Senior Fellow of the Center for Dispute Resolution. He also had been the head of the Center for the Study of Dispute Resolution and is an all-around great guy. But what you might not realize, he's also he arbitrates hundreds of cases. I don't even know how many. It's probably too many to count. And is a vice president of the National Academy of Arbitrators. Today, I'm really thankful that he's here to talk with us about a recent case that came out of the United States Supreme Court. The case is New Prime versus Oliveri. And what came out of it had some implications with respect to other workers under the Federal Arbitration Act. So Bob, thanks for being here.
My pleasure. Let me just say that I'm no longer vice president of the Academy. I was at one point. We rotate off every 4 years, but it's a great organization. I'm proud to be a member of it.
So maybe we want to talk a little bit about this Supreme Court case. So the cool thing, we had an exchange about this recently, and we're kind of talking back and forth about the history and the holding and what it means. And maybe you just want to talk a little bit about the case itself.
Sure. So the one of the questions you asked me to think about was whether I thought the Supreme Court got this case right. And I think the court did get it right simply because it was a unanimous decision. And it is written by Justice Gorsuch, and it was one of his first decisions that he wrote. And so we people who care about arbitration were looking closely to see how he was going to analyze the Section 1 of the Federal Arbitration Act. And he does it in a very interesting way, and it may be a path that the court may begin to take that they haven't taken in a long time. And in fact, really the only person on the court who has sort of taken this path over the past 30 some years has been Justice Thomas. Justice Thomas has consistently said that he believes that the FAA only applies after you've determined that the contract has been formed, and he has been the sole critic in recent years of that the FAA applies in state court. He believes that the Southland case, which the court said that the FAA applies both in federal and state courts, he believes that was wrongly decided, and that may be a case that's going to be in play in future years. But getting to the question of the holding is, I think, based on very limited facts. And the facts are transportation workers. Mr. Oliveira was a driver for New Prime. One of the issues is whether he was an independent contractor or he was employed by New Prime. And one of the important holdings is that the court said it doesn't matter whether it was an independent contractor or an employee of New Prime, he's covered under their decision. And so we'll talk in a little bit about independent contractors and why it's important. And of course, it's incredibly important in today's economy because we know that more and more of people who are employed are working in the gig economy, are in fact independent contractors. But we'll come back to that in just a second. So the issue was whether or not the exemption in Section 1 of the FAA, the Federal Arbitration Act, whether that statement that and other class of workers does that apply only to transportation workers like it did in Circuit City versus Adams, or does it apply to another class of workers? And in that case, one, does it apply to independent contractors? But B, more importantly, does it really apply to everybody else? Does the FAA exclude people who are in employment. A man named David Feller argued all three of the steelworkers cases back in 1960. David Feller is one of the most brilliant arbitration thinkers of the 20th and 21st century. He died several years ago, maybe 10 years ago now, but during his very lengthy tenure, he was one of the most articulate and thoughtful individuals thinking about the Federal Arbitration Act and arbitration. And he wrote a very compelling brief in the Circuit City case in which he said, and other class of workers really applies to all people who are engaged in employment. The court, of course, didn't accept that, and they said that the Circuit City only applied to people who were involved in transportation. And we could spend another hour on, well, what's it mean to be involved in transportation? Is it the clerk in the transportation office? But so far, it really sort of means people who are transporting goods across state lines. The court adopts the same position in New Prime, that the exemption in Section 1 of the FAA only applies to transportation workers. It also says, though, that independent contractors like Mr. Oliveira are covered under the exemption. That's a victory for employees. And we haven't seen very many victories for consumers or employees in the past 40 years under the FAA. So it's an important decision, and it's important because Gorsuch writes the decision, and it's an 8-0 decision. Justice Kavanaugh had just been appointed. He did not participate. Why it's important is, for the first time in recent memory, Justice Gorsuch and the court say a couple of really important things. One is they say you have to look at the front end issues of the FAA, and that's sections 1, 2, 3, and 4. And he says they're a sequence, and you can't get to sections 3, the motions to stay, and sections 4, motions to compel, until you have looked at section 1 and 2. Sections 2 is easy. It's what gives the enforcement to arbitration agreements. It gets rid of judicial hostility. Section 1, though, is where you have this exemption for transportation workers, railway workers, and seamen, and other class of workers. He looks at that section 1 and section 2, and he says, you know, that's for the courts to decide whether or not you can get to sections 3 and 4. We have to look at the sequence, and that's the first time we've seen that terminology, is we have to look at the sequencing. He is, Justice Gorsuch is very much a contextualist and an originalist in this decision. In the past 40 years, we really haven't seen that occurring. A classic example is the Southland decision. Very controversial decision in which the court holds that the FAA applies to the states as well as the federal government. Now, if you look at sections 3 and 4, they both refer to, particularly section 4, the federal government. And we know in 1925 that the act was a procedural act to allow for enforcement and was really a federal act. But the Southland decision in the 1980s had a powerful dissent by Sandra Day O'Connor, Justice O'Connor, in which she lays out why we should be looking more at the text. The majority looked at more of a policy decision that we want to have a uniformity in arbitration, a pro-business decision, and they extended it to the states. Since that time, and there's another allied terminex in which Justice O'Connor says, look, it's worked for 15 years. I'm done. I'm just going to go along with everything because it's working. And that was sort of the end of it. Justice Scalia says, look, I disagree with Southland, but unless I can get 4 other votes, I'm not going to get involved. But Justice Thomas, to his credit, has said since the beginning, look, this was wrongly decided, and I'm going to continue to look at the actual text of the FAA, and maybe now with Gorsuch and with Roberts, they're going to start looking a little bit more closely at sections 1 and sections 2 before we get to sections 3 and 4. And if that's the case, that may be good for consumers and employees. I'm sorry, that was a long-winded answer. The next 2 questions you ask, is it really quite limited to the facts, the decision in New Prime, and should Uber drivers care? On the first one, I think it is limited to the facts because it's limited to transportation workers. Now, the important thing is that they said 2 things. One is that independent contractors are in fact workers, that the employer, employee, master, servant doesn't matter. So they said that the independent contractors were workers under the definition of employment. And that's an important distinction and will be helpful to all classes of workers in the future. But right now it is in fact limited to transportation workers because that's what Mr. Oliveri was. So then whether Uber drivers should care is an important question for a variety of reasons. One is that they certainly are engaged in transportation, so should be exempt from Section 1 and therefore exempt from the Federal Arbitration Act. However, the argument that will be made, I believe, by employers is, one, Uber drivers are not engaged in interstate commerce because they drive locally. So I think the argument that will be made by employers, because the employee will make the argument that I'm just driving intra-state instead of interstate, and therefore I'm not subject to the FAA. But second, I think that the employer will argue, one, we're a national concern. We know from the Commerce Clause that after Wilburn versus Filbert, that if you're growing wheat in Ohio, you're engaged in interstate commerce. That there's an argument that can be made that Uber is in fact engaged in interstate commerce, and therefore you're covered. But the second way that I think employees can argue is to go to, that employers can argue is to go to state arbitration laws, because they may not, there may be an exemption under the Federal Arbitration Act for Uber drivers. They may not have the same exemption under state. And the court sort of left that open as to whether or not employees could use the state arbitration acts. So I think that Uber drivers should care, but I think that it's going to be tenuous, and I wouldn't want to give them a lot of false hope.
That is, Ollie, thank you for that analysis of this case. That is actually very interesting. Thank you all for watching our arbitration conversation.